Hi, everybody, and welcome to another episode of the OutMarket.Pro Podcast, where we engage with small business owners and industry professionals to uncover valuable insights and expertise. I'm your host, Mark Stein. Today, I'm featuring Luby Myrthil. I'm going to get that right. Myrthil, a distinguished member of the Florida Bar since 2012. She specializes in family law, probate, and estate planning, and her journey is a testament to resilience, faith, and community. Welcome to the OutMarket.Pro podcast, Luby.
Thank you for having me, Mark.
So, today we want to talk about trust and specifically revocable living trust. And full disclosure, I have almost completed mine with a different lawyer because you and I just met. And I am so impressed and enthused with this instrument that I really wanted to focus on it, explain to people what it's about, what the benefits are. And so I was so pleased to meet you recently and to have the opportunity to have you on the podcast. So thanks so much for being with us. Let's talk. Let's start at the broadest level, and then bring it down. Talk about there are numerous types of trust out there, but talk about the major types, the major purposes, and more focused on estate planning, and then especially irrevocable trust, since there's a lot of confusion, even on my part, about that, and talk about other major trusts, and then we'll funnel down to talk about revocable living trusts.
Sure, of course. So in the estate planning, like you mentioned, there are multiple trusts. One of the biggest ones, or a few of the biggest ones that we would hear people talk about, we'd have land trust, special needs trust, irrevocable trust, and revocable trust. Now, each of them have their specific purpose. The three that I always explain to people are the special needs trust, the irrevocable trust, and the revocable trust. The special needs, one would only mention that when they have a loved one who is essentially special needs, and you want to make sure that you care for them even when you are no longer here, earthside. You want to make sure that anything that they receive doesn't affect their government assistance. That's one of the major purposes of special needs trust, okay? And an irrevocable trust, which is similar to a revocable trust. So both of them allow you to put your assets into a trust. And so how I explain it to people, think about it as if you're purchasing a house. It's not a home yet until you put stuff in it. So once you've purchased the house, that is what is considered the trust. When you go out and you purchase the furniture and you start to say, this goes into the bedroom, this goes into the kitchen, this goes to the bathroom, those are the assets that you're putting inside of the trust. So just because you've created it doesn't mean it now has stuff in it. You have to put things inside of it. So that's a way for people to picture what it is that they're doing. The irrevocable trust, like it says in the name, it's unchanging. You cannot change it. Once it is set in stone. Okay. And so if you put your things inside of the irrevocable trust, it belongs to the trust. It no longer belongs to you. The trust is a living, breathing thing. It has its own personality. Okay, so it's its own corporation kind of thing. So when you put things inside of it, an asset inside of it, it belongs to that trust. It doesn't belong to Luby anymore. It belongs to the trust of Luby. The revocable trust, similar characteristics. It's like you have the house and such. However, it's revocable. You can make those changes. As long as they're small changes, you can do those things on your own, but bigger changes you can make with an attorney. And when I say by changes, in a revocable trust, if you were to have some sort of asset, money or car, and you put it in the trust, the trustee, which would be the one who is managing the trust property, they can make gifts out of the trust property. They can give away things. They can sell things. They can purchase things to put it into the trust. It's like that is truly a living, breathing thing. It is ongoing. It's its own kind of person, just so we can understand it. I personally love to do revocable trust. That's the one that I'm very familiar with, and a lot of people tend to go towards it. The irrevocable trust, some of the advantages is when it comes to taxes, and maybe on a different podcast we can dive deeper into it. But that's one of the advantages. The disadvantage is once it's in there, it's a wrap. That's it. But with the revocable trust, you can continue to you have a hand in what is going on with your assets. So those are the major differences.
Okay. So, and with the revocable trust, as long as let's just say, let's use me as an example. I've got a trust. I am the trustee until I am deceased, right? So I
Correct.
I don't own the trust, but I control the trust, and maybe I do own it.
So let's think about it this way. We'll go back to our example of the house. So you purchase a house, you now furnish it, you need a property manager if you're not living in that house. So you're the owner of the home, you're the trustor. You created the home, it's yours, you purchased it, but you don't live in it. So if you need to make sure that the house doesn't get squatters and whatnot, you have a property manager. That would be your trustee. So the trustee doesn't own anything in the trust. They manage the things that are in the trust. You can be the same person wearing two different hats. At the time you created the trust, you're the trustor. Once it's signed and it's, you got the blessing and hubba hubba, you can take the hat off and now put your trustee hat. So you're managing the assets in the trust. So as the trustee, you can do anything that you're allowed to do per the instructions in the trust. Okay.
Mhm.
Now, I will say this: the revocable trust does not stay revocable forever. It becomes irrevocable when the trustor dies.
Okay.
Okay. That's why it's beneficial to some people to have a revocable trust, because as the trustor, I can still make changes. I can do this, I can do that. But once I've passed away, the trustee would be someone else. They can't make changes that you haven't instructed in the trust.
Got it.
All right. One of the huge benefits of having trust, period, why people would, you know, navigate towards it is it avoids probate. Now, probate might be an unfamiliar word to some people. Probate is really the division of your assets. It's the division of your things. So if person A passes away, person A has a house, has a car, has bank accounts. Just because we'll do this example. I love to do this one. I am a mom. I have a purse. I have candy, I have money, I have my wallet and keys in my purse. I have children.
Unless your kids find your purse and then you
There
don't
goes,
have
that's a
candy.
great example. That's where I'm going with that example. Okay.
Okay.
So I have a purse here, has all these things in it. Now, my children will think, well, it's mommy's purse. I can get whatever I want in it. While I'm alive, they can't do it because I'm watching them do it. But if I pass away and the purse is still here, they can't take anything out of the purse without getting permission because it doesn't belong to them. Just because they're mommy's children doesn't mean they automatically get the things that belong to mommy. Someone has to give it to them. And that someone will either be the trust or the court. And when you go to court, that's when you do the probate. And that's such a long process. It's so taxing on the family. There's a lot of bickering and such sometimes. And it is overwhelming. It doesn't allow the families to grieve. So more people go towards the trust. The trust, it just, if the things that are in the purse is in a trust, mommy's not here, daddy can give permission to get the things that are in the trust. Daddy can say, yeah, you can go ahead, you can have, because I've already given that permission, right? And one other benefit to a trust, if you're a private person, you don't like people in your business. I'm not saying you're running from the feds or you're running from the mob, but if you don't like people in your business, the trust would be the ideal way to go. Because when you create a will, once you've passed away, that will needs to be filed in the court. The problem is things that are filed in court are accessible to anyone. They can just go down to the courthouse and say, hey, I want to look at such and such person's file. And they can do that because we have public access to courts. So those are one of the things that are differentiated between a will and a trust. So the trust have so many benefits to it.
I don't want to spend a whole lot of time on it, but let's do spend a moment on irrevocable trust because I can't even think of a scenario where anybody would want to have it, and there has to be some benefits, or it wouldn't exist. So, why would somebody want to have an irrevocable trust?
Sometimes it's because they truly want to make sure that the property does not belong to them. Okay. If they have a irrevocable trust, like for example, a house that has a homestead, when you have a revocable trust, you're still living in the home. The courts have found that yes, this is still technically your house. You can get the homestead exemption. It's yours still. You haven't really quite given it up. In an irrevocable scenario, it belongs to that trust. It doesn't belong to you. So one of the things people might do this for is for creditors, to avoid creditors. Sometimes you get tax benefits. There are truly some tax benefits to having your assets in an irrevocable trust. And the way that the beneficiaries are the people who are receiving your assets through the trust, they can get the tax break or there's a benefit to them. Now, I like to, preface this by saying I'm not a tax attorney, I'm not an accountant, so I like to stay in my lane. But those are like the little bits and pieces of it. It's one of those things where you just want it to belong to another entity. It doesn't belong to you and it's protected. There's no way for you to make a change. You don't plan on making any changes. This is the way it's going to stay, and that's that. Some people won't like this because I have it's no surprise that I like to, control my stuff. I have control issues. So if you tell me that I have some stuff and I can't make changes to it, or I can't change my mind, or, it's set, it's done, and that's it, I have issues with that. But people who, for one reason or another, whether it's for creditors, whether it's to avoid lawsuits, because that can happen, because we are sue happy. So people will come, and then they can try to, sue you for whatever. You will put it in an irrevocable trust. You can. So, I mean, it's a little more muddier than that, but it's one that it needs its own kind of conversation.
Okay. Let me see if I can generate a scenario whereby you might want to have one, and then we'll go back to revocable. Let's
Okay.
say you're a multimillionaire, you own 12 homes, and you have a mistress or reverse gender, um, uh, and you want that house to go to them. You're not worried about this is one of a dozen, so you're not worried about it, and you don't want to be taxed on it at any time. And let's say the mistress has so much dirt on you that you don't want it ever to be that she doesn't get this house. There's no reason, because otherwise, either when you're dead or when you're alive, she's going to spout stuff about you. That's true. So is that a scenario? And you got so much taxable income. So I'm thinking, I'm not trying to be political here, but I'm thinking Donald Trump, who has so much stuff and he's got tax liabilities. Is that a good example of why you might want to have a irrevocable trust?
So I would say that would lean more towards why you would have an irrevocable trust, only because you keep mentioning about the tax benefit. You're trying to not of well, maybe you're trying to massage the tax, that you would be required to pay. An irrevocable trust will allow you to be able to go through those loopholes if you have so much money and you're one that would pay a lot of taxes, and you don't want your beneficiaries to be able to be taxed either just because they're receiving things. So that's one benefit to the irrevocable trust. But in your scenario, that would be the only reason I would tell a person, maybe you might consider an irrevocable trust, right? But if it weren't for the tax concerns, both of them would be, both the irrevocable and the revocable trust would be an ideal situation, because once you put the property into the trust, it doesn't belong to you. So when you pass away, no one can come after you. No one can come after your things in your trust, because it doesn't belong to Luby anymore. It belongs to the Luby, to the trust of Luby. So in either situation, like a mistress or a side piece or Mr. or whatever, you fancy, they want to come after you and whatever it is. If I have things inside of either trust, they won't be able to touch it because it doesn't belong to Luby.
Okay. But in a revocable trust, everything is taxable because it does still belong to me.
Technically,
And I think it is reachable through a lawsuit too, right? It's still, as long as I'm alive, is it my asset? Can they come after it?
no, no,
Okay.
no, no, no. They can only come after the trustee, and only because the property manager is managing the asset. So if you if you have a car that belongs to the trust, the car gets into a car accident, lawsuit, the attorney can go after everything that's inside of that trust because the car belonged to the trust. Now, if I'm driving my car that belongs to Luby, and I have another car that belongs to Luby's trust, if Luby gets into a car accident, they can only come after Luby. Even though I'm the trustor of the revocable trust, it doesn't pierce the veil. They can't go through it because technically it doesn't belong to me. But I still have the ability to make changes. I can take the car that's out of the trust and gift it back to me. I can gift it to someone else. I can take it out of the trust and do whatever I want. If it's in an irrevocable trust, you can't do that. It belongs to X person at this point in time. X person will get it at this point in time. No changes.
But I am still taxed on everything in the trust because
You
it
can.
does, as the trustor and the manager of the trust while I'm alive, then it's still my asset. Well, I
So
know
I
it's
will
the
say
asset of the trust, but I
the trust.
control it.
So I will say this just so we can make sure that we are, because we're borderline, we're, going towards the whole taxes. As it relates to taxes, you do have some tax implications on things that are in the trust, whether it be how it's gifted to the beneficiaries or you gifting it. The specifications of that, it would be best served by speaking to a tax attorney or an accountant so they can truly tell you what it is that you are doing and how it's going to, the ramification of it as it relates to tax. Myself as a state attorney, I can tell you the benefit of it as it relates to you legally, or as it relates to you being able to distribute your assets, right? Who it belongs to, who can they sue, how can your loved ones get it, how can you avoid court probate, those types of things. That's where we vary. So in a revocable trust, if I were to pass away, my things would not need to go to probate. My
Right.
children, my husband would not need to pay an attorney to do the probate or anything, and then now going through the whole rigmarole. It's already handled in the trust. It's immediately effective upon signing.
And that both of those two things, I'm sure we'll come back to it. Those seem to be the major benefits, that there's not the time involved, the hassle and heartache of going to court. Actually, there are others. The uh, the heirs, the survivors, there's no reason to fight because it's all decided and it's all going to be implemented as written. So there's no
Correct.
point in fighting over it. No
Correct.
challenges, right? Well,
Correct.
let's stop with that for a second. Is there any way? There's always a way that people can challenge anything, but is there a mechanism to be successful in challenging an assignment from a trust to an heir?
Absolutely. So when it comes to trust, one of the things that we talk about, why one, it's the trust, excuse me, creating a trust is very expensive because you don't have the court, big brother, looking over to make sure what the trustor wanted is exactly what is written or how it's being distributed. So you're going to have to rely on the trustee who you've assigned, okay? The challenges may come in if the trustee is doing something that is, or if the trustee is interpreting an instruction that is a different thinking than what the beneficiaries believe it should be. The interpretation is completely wrong. So a beneficiary can come and challenge how the trustee is managing the assets in the trust. And the trustee has a fiduciary duty. And that is a legal term, that's a term of art. The fiduciary duty means you have the obligation to do everything in your power to make sure that you're following all of these guidelines and you're looking at the best outcome for the beneficiary. You're looking at the best interest of the beneficiary. So if there is something if there's a property out there that you've been instructed as the trustee to get, you can't do anything that would contradict that. If you find that it would best serve you personally, you can't now go and try to fudge the numbers, mess up the deal or so just because you personally want this piece of property. You as the trustee have a fiduciary duty to work in your beneficiaries' best interest. The way you manage the property, the way you manage the money, the way you distribute the funds, you have to make sure everything that you do is written and it gives you the authority to do that. When you don't, then the beneficiaries can come back and ask the court to remove you as the trustee.
Okay. So this seems to point to the importance of making sure, if you're creating a trust, making sure that the language is clear. It also is a responsibility of the attorney helping, but making sure
Correct.
that the language is clear and unambiguous so that it's less likely to be misinterpreted.
Correct. That is very key to make sure that the verbiage is as clear as it can be. I mean, sometimes, we have human errors where if the trustor is, thinking one thing and the attorney wrote it the way that the trustor wanted, and both parties are looking at it, it's like, yeah, this is clear. You always have the possibility of someone else coming and say, well, that comma actually means this and that, not together, because by virtue of the comma, you have the linguist that would come in and, the comma and whatnot. So there's always, room for possibility of litigation. The goal is to limit that or minimize that, mitigate the damages as much as possible. So making sure that you work closely with your attorney, that truly what you are articulating is written in the trust correctly.
Mm-hmm. So we're avoiding probate.
Yes.
So everything upon my death goes right where it's supposed to be,
Yes.
assuming my trustee um, interprets it properly
Yes.
and executes it properly. And then also, we're not going to have lawyers involved in this process.
Correct.
Let's say let's generate a scenario where we don't have a trust, we do have a will, and talk us through what happens in terms of legal fees. Let's just focus on that.
Oh boy. So in Florida, there is a Florida statute where the attorney's fees can be 3% of the estate value. Okay. It's not required, but it is something that is agreed upon by the, let's start over because that's not even going to get you to where I am already. Okay. So we have Mother A, who has all of these assets and have 3 children. Okay. Mother A, in this scenario, did she create a will, you say?
Yes, she has a will, but
She
no
has a will.
trust.
Okay. Mother A has a will, and she thought that she was doing everything she could for her children. All right. And she put all these assets and stuff in the will. All right. She's now passed away. In the will, you have to appoint a personal representative. That's the executor. That person is the equivalent to a trustor. So if you're talking about a trust, you're called a trustor. If you're talking about a will, you're called a personal representative or an executor. Okay. So it could be anyone really that you pick, but there are statutory requirements a person must meet in order to be approved as the personal representative, but that's the court that goes into that detail. Okay. So Mother A picks her sister B, to be the personal representative. Mother A passes away. She's already dictated how she wants Sister B to distribute everything. Sister B doesn't have the authority. Everything still belongs to Mother A. Sister B can take the will, and let's just say part of the will was to sell the house, split the proceeds between my 3 children. So Sister A takes her will and she goes to the realtor and say, I have the authority to sell this house and split between the children. The realtor will say, yeah, but no, it belongs to Mother A. So no, I have a will. Unfortunately, the will doesn't have the bite or the authority to give Sister B the authority to be the personal representative. So now Sister B have to find a lawyer, and then that lawyer will now have to file a petition. A petition is like an ask, so that the court can give Sister B the authority to be the personal representative or the PR. What is that looking like in as far as fees go? Well, attorney's fees, court fees. If you can't find, let's just say 3 of the children are grown and one lives in some far out country and have not had communication with the children or mom, now Sister B and the attorney have to go find a missing child. Let's just say one of the children have passed away and they have grandkids. Now they have to go find, not grandkids, but their kids. So now they have to go find those kids because they're entitled to the beneficiaries, to the assets. So all of these things are racking up the attorney's fees. It's just going and going and going. And then let's just say there's issue with the house. So now the PR have to do everything in her power to make sure she gets the most for her, the most for her buck here with the house. So if she needs to make the house marketable, and maybe Mother A have, in her ailing age, didn't take care of the AC. And in Florida, it's hot. So we need the AC. And so, you got to fix the AC, you got to fix a roof. And so now you're going back and forth with the seller. Those are
And
real estate.
where's she gonna get the money? Where
Where
is
is she going
Sister
to get the
B
money?
to do this?
Sister B either have to has her own money to do all of this, or if Mother A had money in a bank account, then the court would have given Sister A the authority to now take the money out, put it in a estate account so that she can be able to do these things. But if Mother A didn't have this liquidated asset and everything that she needed everything that she had was in the house, Sister B would now have to come out of her pocket to pay for attorney's fees, pay for this, pay for that. The good news is the court do recognize that not every PR, have the financial ability to do these things. So they have authorized the PR to be reimbursed for every expense, as long as it's for the estate. Well, the biggest thing is, in order for me to be reimbursed, I had to have spent it. In order for me to spend it, I had to have had it. Do I have it? Is the question. So those are the legal things that you come across when you're going through probate. And while Mother A ultimate goal was I just want my kids to just get my house, split it between them so that they can live, a life that I've maintained for them. It is inundated with all of these legal stuff. Okay. And I go according to Florida statutes. My fees are 3% of the estate value, the estate value. Okay. Now you're going into homestead exemption and not homestead, that those are like really getting into the weeds of it, but just keeping it on the surface, that would be the attorney's fees.
Is it equal to 3% no matter what, or is it up to?
This is something that you can negotiate with the attorney and the PR. You can do that. For me, it is 3% of the estate value.
Okay.
In addition to extraordinary things that I have to do that are not regular, that are not normally part of the probate. Finding the beneficiary, maybe battling with the creditor who now says, hey, I have this, but then is the creditor entitled? Because there's some things that are protected. Your house is protected. If that's the mother's homestead, maybe mom had two houses and the vacation home has a buttload of money, right? So now you have to, but there's no money to pay the creditor, but the creditor has it, they have rights to be paid. There's this money here. So it goes back and forth. There's so many things that are involved in a probate, and all mom wanted to do was just split everything and give it to the babies. Well, not so baby, but those will always be her babies. When it comes to a trust, while it is more expensive in the front end to create the trust, you don't have to worry about the other stuff that comes with the probate and the will. Now, I will say this, I have a caveat to this. There is something called a pour over will. It's like pouring something over a will. A pour over will protects you, the trustor. Now, in a trust, if you've been paying close attention, I haven't bored you. The trust is it has the assets you are aware of. You have a house, you have a car, you have money, you have business, you know. These are things you know. What about the money that comes in as a result of your death? Think about wrongful death, or medical malpractice. People die on the table all the time. It's never the intentions of the doctor, their purpose is to save you. Or you get into a car and then now you die due to a car accident, and your estate or the PR or your trustor goes and sue the at-fault person. And the jury or the judge finds, or maybe they come to an agreement, settlement. Yes, this was wrong. This was a wrongful death. There is this, you're entitled, your settlement is $100,000 or more. This money was never part of the trust.
Right.
This money is now lingering out there. And your sole purpose for creating a trust is so that you won't have any of your assets lingering out there. Now, not only have you spent money on creating a trust, your beneficiaries, they're now going to have to spend money to do a probate on this $100,000 settlement. So to avoid that, not to avoid, but to minimize the trauma and the financial burden on people, they came up with the pour over will. And that is usually created at the same time that you have a trust. So what it typically will say, everything that is named, everything that belongs to Mother A needs to go into the trust because that was her purpose. Or maybe if you have a trust and you went to open up a bank account, and instead of it saying the trust of Mother A, you put the Mother A trust, but that's not the title of your trust. So it's now lingering out there because you don't have a title named Mother A Trust. You have a trust, the pour over trust also catches that too. The pour over is like a catch-all. Anything that is mistitled, anything that is not mentioned, anything that belongs to Mother A, period, bottom line, needs to be put into the trust. So
Even
now,
post death with this
even post that.
lawsuit.
Yes, because the settlement belonged to the estate of Mother A. But Mother A never put it. Let's just say Mother A was smart enough and she have a trust. Okay, forget the will. She now has a trust. Mother A didn't know this is how she was going to pass away. So now we have this settlement lingering and nobody to catch it. So she created, or she signs, a pour over will. That pour over will take care of that settlement, will take care of that bank account that is mistitled, will take care of everything and put it into the trust. You will still have to pay for an attorney, but your fees will not be the 3% of the trust. It will just be for the attorney to be able to put all of this stuff into the trust. You still have to go through probate. You still have to go through the rigmarole, right? But it's not for the things in the trust. It's only for the things that are lingering out there. And it's not so burdensome because we know the entity that's going to receive this settlement is the trust. So there's no one to look for. We already know that it belongs to the trust. So it minimizes the amount of work that the attorney will have to do. It minimizes the cost to the personal representative, the trustee, so it's a catch-all and it gives you an extra protection. It's like having suspenders and a belt on. Like your pants not going anywhere with the suspenders, but why not put on a belt, So it's like the two, just in case the suspenders snap off and then your pants falls, whoa, got the belt. So it protects you. That's one of the benefits of having a pour over will.
Am I
And
understanding?
it will be filed and it is available for public access. Okay, the public will be able to see your pour over will, but any nosy Nancy won't know too much because all it will say is everything that Mother A has, everything that Mother A owns, this, that, and the third will go into the trust. There's no detailed description or anything in that pour over will. So Nosy Nancy can go ahead and look up that pour over will any way she wants because she won't know anything or he won't know anything that's going on.
And it also covers, the pour over will also covers, let's say there was a mistake. Well, actually, mine does specify almost everything that's in the trust is specified in the pour over will. So maybe mine was not done properly.
No, well, it can do that. Sometimes I have seen attorneys who have written certain things out in the pour over will for sure. Is it necessary? It depends on why the attorney is doing it. Sometimes they want to make sure that the things that I would bet that the reason your attorney or an attorney would do that is because if something were to happen to you upon signing, you haven't funded the trust yet. So if you sign, you come into the office and you sign, you go out the door, you get hit, the trust is empty. You just bought an empty house. There are no furniture, there are no nothing. But in the will, it covers everything and it says these things were meant to go into the trust.
Yeah.
So I want you, attorney, I want you, judge, to please allow the PR to put all these things into the trust. So that's, that's one of the ways to do that for sure. But people who don't want too much, their business out there are ways to do it. They're both of them are fine. One is, giving giving the protection until you actually go fund it, because you have to be the one to do the work. You have to um do a quit claim deed from your house, your home, yourself to the trust. You have to change the title of the car from yourself to the trust. You have to go now open up a bank account, for the trust. There are legwork that you have to do. Remember, when you sign the trust, you're literally just purchasing an empty home. You now have to furnish it. You now have to take the trust and give it to your financial advisor and say, hey, I have a trust. I need all my money inside this trust, and they need to do it. In the meantime, in between that time, we make sure that we walk around with our bubble so that we won't pass away before our things get inside the trust.
Yeah. And my attorney did take care of some of the things like changing the deeds. But there are some things like going to the bank and changing the account from
Yeah.
my personal into the trust. So there are
Yeah.
certain things. And just for the viewers out there, it is a pain in the ass. Um, and I still have one small thing that I haven't moved into the trust. And every entity has different hoops to jump through. This is a small piece of stock, but if I want it, and I had to go, it's just so it is
It
a
is a pain.
hassle.
It really is a pain, but think about it. I'd rather be the one to go through the pain now and get it done right than for my children to be the one to have to now deal with their hassle and don't do exactly what I wanted them to do anyway. A trust and a will, but a trust mostly. It's like, your hand beyond the grave. I'm a mother. So you better put that. Did you brush your teeth? You better not, So if I'm, working beyond the grave, it's like, I didn't want you to get this house. I wanted it for this one. So you're the one that's still dictating.
Right.
Yeah.
Um, let's see. I had another question, but I've lost that one for the moment. Let's talk about who would not benefit from this at all. Obviously, oh, I know what it was. Um, I co-own some property with some farm partners, and I asked them if they wanted to do a trust uh, for the property. Anyway, they said, I'll be dead. I don't care. So there are a lot of people who say that. I also, as you know, I used to mediate divorces, and I would bring up life insurance. This is sort of related, but not really. I
Yeah.
would bring up life insurance, that this is a good time if you don't have life insurance to specify. We were in Kentucky and Indiana, and you're not mandated to have life insurance in a divorce. I don't know what it is in Florida, but um, so I would tell the story about a comedian who was on a talk show. I forget who he was, but they were somehow talking about life insurance. And he said, I don't have life insurance. I don't believe in it. When I die, I want it to be a total tragedy.
Oh
so,
my God.
so,
And a total tragedy it will be.
yeah. So, and a lot of people feel that way. I don't care. They can fight till the cows come home. I
Yeah.
won't be here to listen to it. So
Yeah.
have at it.
Yeah.
But let's say, so let's do talk about who might not benefit from having a revocable trust. Obviously, if you don't own anything, if you're just pushing a grocery cart with your clothes in it, then you don't need to worry about it. What
Right.
if you what if you just have a spouse, you don't have children? Can everything go immediately to the spouse and not have to worry about the trust, having a trust?
Well, absolutely. So, and you have to think about how are the things titled, while you're alive. So, if you have a spouse, and when we purchase a home, it will say as a married, whatever. So if you pass away, your spouse would have it's tenanted by the entirety. So it all goes to them. So there are certain things, if the only beneficiary is your spouse, a trust, and it depends on actually the assets as well, because my legal mind is now going all over the place. So if you only have a spouse and you're thinking that everything is going to go to your spouse, you will still have to go through the probate process, because if it only belongs to you, it doesn't automatically goes to your spouse.
What
But
if
if
everything is titled in both names? Your
Oh, you don't
vehicles.
even have to worry about it, because it automatically goes to the spouse. As long as it's titled, like if it's joint of right of survivorship, tenants by the entirety, we have everything, there's no need, because it goes to your spouse. And if that's the only thing you're worried about, then that is fine. But if everything is in your name and the spouse's name, but your spouse dies before you now have to think about, what am I going to do with my stuff?
Oh, okay. Oh, I got you. Okay.
Yeah. So if you're thinking your scenario, you're thinking you died before the spouse, everything goes to them. But in another scenario, because we never know when we're checking out, another scenario, let's just say your spouse dies before you. At the time when your spouse dies before you would be the time for you to think about, you know what? I didn't think about it before because it was just me, either me or him, me or her, whatever it is, right? Um, it this was automatically going to go to this individual, but now there's no individual. So what do I want to do with it? You now have to think about it. A lot of times, though, people think because they don't have assets that they don't need some sort of protection. You definitely positively need some sort of protection, because you still want your say in what happens to your things. If it's something very small, like you have a house or something, and it's your home, a will is perfectly fine. You can do that, because the house, if it's your house, you've lived in it, you have homestead protection, creditors can't come after it. So you would be fine, technically, barring any other issues that come up. But for those who are, I'm going to be dead, and that's their problem, not mine. I get you. I understand. But for those who have a bleeding heart for the ones that are left over, that's left behind, you want to make sure they don't fight over it. And the other thing is, you've worked so hard for the things that you've acquired. You don't want to leave it in the hands of the wrong person that's just going to blow it in 5 minutes. Like, this is all your hard work. You want to leave it to someone who's going to appreciate it and who's going to put as much love into it that you did. So that's one of the other reasons you want to think about who's up next, who's going to get my stuff. Because if it really
Mhm.
didn't matter, you would have just did enough for you to, make it through and just live off of Social Security. But that's not the fact. That's not the case here. You want to live a good life and you have some money. So it's like, now, which one of these spoiled kids did I want to leave it to?
Yeah. And I bet the same phenomenon happens in these cases where a kid gets a windfall, just like people winning the lottery. I think the studies show that it's gone in a year or two. It's never
Absolutely.
invested. It's never dealt with wisely.
Well, yeah, because money that comes easy, leave easy. If it took you a long time, if it's hard work and you got that money, every penny is like it has value. But if it just came to you and it's like, oh, you don't understand the work it took to get that money. So you're just blowing it. You're going, you're traveling, you're going, and then in a year from now, you're back to where you were. You're regretting your decisions. Maybe you're not, but you know that you're back to where you were.
And mom is not going to be happy looking down at you spending all that
No,
money
absolutely
on
not.
trips.
Absolutely not. She would come in your dreams and say, didn't I tell you not to spend my money? Why are you spending my money? So yes, I'm telling you, I have a control issue.
um, in my particular case, I also had a very complex situation where I've got one heir, one daughter, and I've got several businesses, and she's expressed no interest in being involved in the business, now or in the future. So I had that to deal with. I had a not-for-profit that I'm involved in, and I wanted those funds to be able to go there uh, into that. So I think people with relatively complex situations, even if it's not that much money involved, it's about having things go, like you said, responsibly to somebody
Yes.
who's going to take care of it in the right spot.
Absolutely. Absolutely. You want it to either continue, or you want it to be well managed, or you want it to be handled in a responsible manner and given to, others, someone who's going to benefit well from it. Someone, if you have a nonprofit, you definitely want for the nonprofit legacy to continue. So you do. So, you want somebody to fund into that. If you have multiple businesses, you definitely want to be like the Walmart of your business, like, oh my goodness, this started back when, and look at where it's grown now. So it's ideal to be able to say who is going to manage later, how are things going to move, how should what does the business contract say, and things of that nature. So these are really important. It's not just going to, you can't just assume that people are just going to saddle up and just take on over and do the way you did. It's best to have that conversation while you're on Earth side, so you can know who's going to continue the work that you've done.
Right. Okay, I remember that point or question I had. And by the way, I put an asterisk beside a note about Earthside. I like that. Although you could still be Earthside if you're down below, you're just below Earth.
Well, so, but now remember, so we're Earth side with our spirit, our soul inside. So your body is going back to the Earth where it came from, but your soul is no longer tied to Earth side. At least I hope not, because there'll be a lot of, casting out demons.
Okay, so here was my thought. Hardly anyone, this has got to be an education challenge, because everybody thinks, oh, I've got a will, and what I say goes, and it's going to go where it's supposed to go. And I don't, I bet you 2% of the population knows what can happen during probate, all the challenges, all those attorneys' fees. I think the general awareness is very low about this, which is why I wanted to have you on to talk about this tool. And very few people are aware of the existence of a revocable living trust.
Yeah.
So it really is an education process, because I think 99% of the people think I've got a will, it's going to be easy, and I have totally and completely taken care of things, and they haven't.
Yeah. And I will tell you the reason for that. First, I want to say, of that 2%, I can bet you 75% of that 2% only know about the nuances of a will because they've gone through something similar. When people come to me for a trust, they would say, oh, I did probate on my mom, and there was a probate on my dad. My cousin went through this and it was horrible. I don't want to go through it. So they've been exposed, and it's like, there have to be another way. There has to be another way. And so that's why they educate themselves on other possibilities, so they won't go through what this family member or this friend or so have gone through. So their education came because of exposure. But one reason why the general population are so focused on, or only have knowledge of a will, because those who do have knowledge of a trust will say, well, that's a rich man's thing.
Mhm.
It costs too much to get a trust. If I could just get this will, I don't have to worry about it. And truly, they don't have to worry about it. They get the will for however much it is, and that's done. But they don't understand or have not been educated on what happens afterwards. You've created this will, that's great. Good, kudos to you, because a lot of people don't even have a will. But what does that mean for your family? And if you're dead set on keeping the will, think about putting something aside for the probate cost, the attorney's fees, because that's what your family is going to have to deal with. A lot of people also think, oh, well, I have a will, it's fine. My family get along so well. They don't, I don't see anybody fighting and such. And I tell you, when money is involved, oh my gosh, the hidden demon, the hidden green-eyed monster that they've been suppressing because everybody's playing nice, now starts to rear its ugly head. It's like, no, 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 wait 1 second. I've dealt with this long enough. Mom and dad's not here, and I'm sick and tired of you guys telling me. And now everybody feels entitled because mom wouldn't, dad wouldn't. And it just makes the process even longer. So if you have a trust, you don't have to worry about them going back and forth. You don't have to worry about, well, mom and dad was old and you're the one that was with them. So you changed their will, you changed their mind, you did this, you did that. The trust is the trust, and it's how it's set.
Do you think there's any point in civic discourse that where this should be mandatory for people to know? It seems like somebody needs to tell everybody about this, but I don't see any point in life, any phase in life where it should come up. Like if you're going to get married and you're in a church, a lot of times the church requires you to do premarital
Premarital
counseling.
counseling, correct.
And even education programs for teenagers, that's about bank accounts and that sort of thing. I don't think there's any point where it's obvious that everybody needs to hear this.
Well,
You?
so I do. I think as soon as the high school kids are about to graduate, they should have some sort of knowledge of a state as a whole, however term, because they're adults now. Their parents are not going to be making decisions for them. They're the one that's going to make decisions. Uh, if something happens to them and they're in a coma or they're going into surgery, who are you going to pick to make these medical decisions? And what is it that you want? Because you've been relying on your parents to make these decisions for you. At some point in time, before you head out into the world as an adult, these conversations need to be had. The problem I see, or even when you're getting married, these conversations should be part of the premarital courses, because it's like, okay, you were just thinking about yourself. Now you're linked up with this person, legally binding. So this is what this means. This is what this has to happen. And we don't want to talk about divorces, but hey, if a divorce happens, maybe premarital counseling wouldn't be where you talk about it. But if maybe they're going through some marriage counseling and is going towards divorce, and so it's like, hey, as a divorce is pending, or it's coming around, you guys need to think about who's going to make decisions for you, because you guys can't get along and you don't want the one person to pull the plug just so they can get you out of their life.
Right.
You don't want to think about that. The only hiccup I see to that being some sort of mandate or even something that is proposed, these conversations would have to be had by an attorney. Because when you talk about them, you have to, if you're not an attorney, you have to be very careful how you talk about it so that you won't be doing unlicensed practice of law, because you're giving essentially legal advice. So maybe having a seminar with a forensic accountant, I'm sorry, my mind just went to trial, financial accounting, a life insurance agent, and an attorney. The three of them together can give that financial aspect, or the what ifs of life, and everybody can put their pieces into it, or their advice into having these conversations. But the perfect time, I feel, would be when you're transitioning into different phases of your life, from child to adult, from single person to married, from the one being cared for now being caretaker, from married to divorce, so maybe you are now getting older and you can't navigate like you used to. You want to make sure that the person who's taking care of you is the one you want, the child that you want, the friend that you want, not the person who for public sake could pretend to tolerate you. You want to be able to make those decisions. So truly, in a short answer would be, in every stage where you're transitioning to a new phase in life would be the ideal time to have that conversation, that education of how it's going to affect you in this phase.
Mm-hmm. And so maybe age of majority, whether it's 18, 21,
Yes.
maybe this uh, actually, if you got together, if the legal field got together with accounting and insurance fields, and they said, okay, we are going to create an entity that will provide free counseling, free informative counseling. It could actually be good for business for all three of you because you could pick up some business along the way. And
Mm-hmm.
we will donate an hour for every person turning 18 or 21.
Oh,
Uh,
that would be wonderful.
maybe that's the
Oh,
end.
that would be wonderful. I think that would be wonderful because it doesn't give it eliminates any excuses
Mhm.
that the individual would have. Oh, I don't have the time. Oh, I don't have the money. Well, we can make time for you. Someone else is paying for it. Let me educate you, however long that takes. And let me feed you at the same time. How about feed and education kind of thing? People come for food all the time. So yeah, that could be worth it, actually.
It would just take a lot. It's hard to get any one profession to
Oh,
agree to
yes.
do anything, so much less three. Well,
Yeah. Yeah.
you've done a great service by being on this podcast and informing everybody who happens to catch it on YouTube
Yeah.
or other podcast channels to be able to hear this and at least to be aware of it. The only way that I was aware of it and was that it popped up on my YouTube channel. And I go,
Mm.
oh, what is a revocable living trust? And I'm curious. So I started looking into it. And lo and behold, it's a great
A
thing.
tool to have. Yeah. Yeah. And I'm just very honored to be able to speak about it. It's something that I love to do. I love to educate people. One of the saddest thing in life is to be able to, it's when you come in contact with a family member that says, no, there was no will. No, that we're still fighting. No, I've been trying to get my parents to do this, but they thought the way that they've been doing it is working just fine. That actually just recently happened. And it is the third generation child who is now talking about, well, what are we going to do? I've been telling my parents that they need to get this corrected for quite some time. And now it's a huge burden on him and his generation, So it's a pleasure to be able to give some sort of insight, to educate anytime that I can. And any person who wants to have an in-depth conversation on their situation and what tool would best benefit them, they can give me a call. I do offer a free consultation for estate planning.
Great. Well, let's move right into that. Give them your phone number, your website, your email address, anything that you're willing to. Don't give your personal residence address, but uh,
No,
what
no,
what
no. While I like visitors, I don't like visitors.
and they'll all come over for dinner on the same night.
Right.
Uh,
Yeah, they will. Tonight we'll have cereal for dinner.
so
Yeah.
give your contact information and we'll also put it down in the show notes.
Sure. Okay. So my name is Luby Myrthil, and my firm is Myrthil's Law. It's an interesting story as to why, but it's Myrthil's Law. And my phone number is 813-445-6363. My email address is luby@myrthilslaw.com. And you can contact me any of those two ways. We'll definitely schedule a time for you to have your free consultation for estate planning.
Now, do they need to be you're in Florida, Tampa Bay, by the way. do they need to be a Florida resident to talk to you?
Absolutely. So I am licensed in Florida, um, and I can only give the information, legal analysis, I like to say, as it relates to Florida law. Every state have their own law as it relates to a will and a trust and such of that nature. So it would be ideal for you to, if you're not in Florida, you can look up your bar association and they can give you a phone number and address to an attorney that would be able to help you. Now, I don't
Well,
know if they give free consultations, but yeah.
I would suspect a lot of lawyers do, and if they're just wanting to Google it, they would Google estate planning lawyer
Yes, in your state
in
or
your
even
state.
your city too. Yeah.
Okay, all right. Um, well, thank you so much for educating us and clarifying some things for me about it. I'm such a fan of Revocable Living Trust, and I really appreciate you being on the podcast.
Oh,
So be sure you look for Luby's contact information in the show notes if you're in Florida. If you like the episode here on OutMarket.Pro's podcast, click the like, subscribe, and the notification bell to find more topics in the future. So thanks, everybody. Luby, thank you so much. And we'll see you guys next time on the OutMarket.Pro podcast.
thank you.